Hey, good afternoon, everyone in business law. I'm going to put up a new video covering Chapter 1 and hopefully Chapter 2 today. I'll get both up on the Blackboard site. But I just got out of court, so I'm kind of wound up, and I thought I'd try to use the energy in a positive way. And I thought I'd put up what I would think are the salient points in summary fashion, what I thought were contained in Chapters 1 and 2. I'm going to keep them separate because no one likes a long video. I'm going to go long anyways. But most people like to have their videos relatively short. I know if somebody sends me a video more than 5 minutes, I don't even want to watch it. But I feel like there's a need to put up a lecture to kind of go over the things that I think are kind of important and act as a way of our discussion, if you will, or substitute for our discussion in class. And what I want you to do is, after reviewing it, don't be afraid to shoot me an email or give me a call, text me a question about what you felt was unclear or that you wanted more additional information on, if at all. And if it simply just helps you augment and understand the material in the chapter, great. I do urge you to watch it, or at least listen to it. You don't have to watch me just sitting there, just talking. I do tend to go long, and I apologize for that, but I'm just trying to make the course as enriched and as responsive as I can make it be. There's also good videos that I'm going to find, or I already have, that professional people in the field have posted on YouTube, and through licensing, through fair use, or links simply to YouTube. I urge you to watch those. They tend to be tighter, clearer, and better than ever I can do, but it's still not me, and I think I owe you an obligation to put some thoughts up there from me, what I think about the important chapter. So without further ado, I'm almost already 2 minutes in, and it's longer than the video that I'd like to watch. Chapter 1. Business law can't just start off with the heart and soul of business law, which is contracts. It's got to start off with a backdrop of what is law, where do you go to resolve legal disputes, and the foundations upon which our legal system rests. Because without that, it's just pure theory, sort of out in the air. And so Chapter 1, I think, does a nice job kind of giving us that foundational understanding of where law comes from and how it gets applied. So that's where the chapter begins. I love the concept of what is law. Every so often, if I was live in class, I might call on you. Some people think be picked on because what is law? And I know if I gave you a multiple choice test, you'd clearly be able to pick out the answer, but to actually articulate the response sometimes it's a little difficult when you first get caught off guard. But I think it's important to define it. Generally speaking, a law is a principle or rule that the government's willing to enforce its parameters or its elements with a sanction or some form of punishment if not followed by the citizens. Now, sometimes people, and I still get friends who are lawyers, some of them aren't, will send an email loop around funny laws that still exist, but we know they're not going to be enforced by the government. So I always add that to the definition. It has to be a standard by which the government is willing, able, and will enforce with its authority if someone falls outside the conduct that's prescribed by that rule or principle. Now, I often get this sometimes. I'm thinking about my daughter recently, who now she's 25, getting old. She hated the fact I used to have these fluorescent yellow Crocs, and I used to wear these things all the time. And I used to bring her to dances and over to a friend's house, and she'd always ask me to drop her off a block early so she wouldn't be humiliated by my Crocs. And then as she was getting her driver's permit, I always remember her telling me that it was illegal to wear these Crocs because they were a type of sandal. And I'm like, really? I said, where's that? She goes, oh, it's in the law. I said, so I'll tell you what, get me the law, and I'll spring for dinner wherever you want to go if you can find me the law. And she goes, well, everyone knows it's the law. I said, well, I don't. And I said, get me a copy of the law. And she couldn't produce it because there's no specific law dealing with it. There's a principle called impeded operation that sometimes lists inappropriate footwear, but the color of my Crocs certainly didn't make them inappropriate for driving just to be associated with. So my point is you have to know what a law is, where it comes from. And sometimes there are laws in books, meaning statutory laws that are statutes or regulations that exist. But that doesn't mean they're still enforced. Sometimes there's a concept called falling into suetude. The government simply doesn't enforce it. Recently, here in Massachusetts, the adultery statute was repealed. But for many, many years, it was on the books. But no prosecutor anywhere in Massachusetts was prosecuting someone for adultery, even though we might recognize it as a moral, ethical wrong. It lost its standing really as a law because the government wasn't willing to prosecute such claims in Massachusetts, at least. So anyways, we know the objectives of the law. It's pretty clear in the book. We live in a civilized society. We have to have rules in order to resolve disputes civilly and also in the criminal, but maybe civilly in this context, is without resort to violence. It has to have a fair system of somewhat predictable outcomes if we agree upon what the facts are, how the rule of law should be applied, and what the outcome should be. We want that mechanism in order to keep some kind, especially in the complex world of business, predictability in how we behave and what we can expect from the other parties involved. Roots of our legal system, the common law. I don't like how the book describes the common law. For our purposes, the common law is court-made law. There's sometimes in history, especially early history, from our English roots, and there are roots from many other countries, but especially from England, the common law was an area where there was conflicts or principles that needed to be established, and they didn't have the legislature to fill in that gap, and these courts of equity would do it. Courts of equity meaning they had power to create justice in any given controversy. And they would create principles out of that, and those principles lived and grew and became accepted as part of the cultural heritage of the English nation. And of course, the colonies largely at some point became dominated by the English common law. In things like the concept of negligence, being able to sue another person because they've done something irresponsibly causing property damage to me or personal injury to me. That's a concept of negligence. It's not framed in a statute. It's framed out of the common law court-made principle. So there's four major, the ones I want you to know and that you should know is laws really come from four major sources. And I'll go in the hierarchy. The most important, the highest law of the land, the Constitution. Now to complicate things, and I'll do more of that complication in chapter 2, we have two sets or two bodies of law. One are federal and the other are state. And so the federal Constitution is the supreme law of the land. There's a test question right there. Because no law that's lower than it within the federal realm or no law in any state jurisdiction or local municipality can be in violation of the requirements and mandates of the U.S. Constitution. It's considered null and void as unconstitutional. You guys already know that intuitively or from classes you've taken in the past. Now, what's interesting about that is the Constitution is not going to come up regularly in business law context. We're probably going to look at a lower form of law like statutes. And we know that the supreme law of the land is the United States Constitution because there's literally a clause in it that all the states agreed to adopt when they ratified our Constitution. And that's called the Supremacy Clause, that federal law will be supreme over state law if there's a conflict. But they have to be conflictual. Sometimes they can coincide at the same time and have what we call concurrent jurisdiction or overlapping jurisdiction. But generally speaking, if it's in conflict, the federal law will trump state law if the state law is in contravention or in contradiction of the federal principle. So Constitution, highest law of the land. In the federal realm, it's the U.S. Constitution. And if it applies to state behaviors in the state realm as well, we know states have to abide by the minimum standards in the federal Constitution, or the state constitution or state law is null and void as well. So we have constitutions. We have 51 of them, right? We have the federal Constitution, which all other laws must abide by. And then we have the 50 individual state constitutions, and they can be very, very different. Massachusetts actually is older than the federal Constitution. And if you read both, the federal Constitution lifted a lot of the Massachusetts principles within it. If you love history like I do, some of you are going to have me in my history classes. I teach a lot of history, political science, and law. It's sort of all interrelated in my opinion. So that's the highest law of the land. The next is statutes. And that's what I think when someone says something's against the law or the law requires. I do a lot of criminal defense work. And in the realm of criminal law, it's almost all statutory. Our state legislatures and the federal legislature, the Congress, create laws, and we call them statutes. On the federal level, we often call them the code, the United States Code, but it's statutes. In Massachusetts, we call them Massachusetts general laws. Those are statutes. They are the second highest form of law. The only thing higher than that is the state constitution for state laws, federal constitution for federal laws. And we know if a state law, statute or otherwise, comes in conflict with federal law, the federal statute or the federal constitution will strike it down as being a contravention of federal law. The next one, which is no one in his class, well, maybe somebody will know who Rodney Dangerfield is. He was a comedian that was really big when I was a kid, and his catchphrase was, my dog is down here. It's a puppy, and I just took this out of the other room, so I'm trying to be puppy watching here at home as well. Now she's biting me. The Rodney Dangerfield catchphrase, I get no respect. And that's the third in the largest area of law. That's administrative law. I guarantee you, as a student at the Mount, or you're looking at this video from another institution I might use for it because I teach business law at the colleges as well, there's all kinds of regulations you probably had to deal with as a student. And I had to deal with as a member of Mount Wachusett Community College or other colleges, administrative rules and regulations, because the federal government says in order for something to be a college level credit, there's certain requirements that have to be made before financial aid can be given. The Board of Higher Education creates rules and regulations for a program of study to be approved for an associate's degree, for example. And those of you that deal with the Registry of Motor Vehicles, I have a bunch of kids, adult kids who drive cars, and there's always somebody not paying their excise tax, or they have tickets they didn't pay for and they go to renew the license and they can't. Those are sometimes statutes, but they're oftentimes regulations. They create administrative bodies to deal with the specialization and special knowledge that's needed for that area. They propose regulations, and as long as they're not contradicting a statute, because they are a lower form of law or a constitutional principle, they are law. They're called regulations, but they have the full force and effect of law. Regulatory areas, those of you that, I don't know if I have any of this class, but I always seem to have a few people who are into like hair salons and things like that. There's a lot of licensing that goes on in the regulatory field with that. Being an attorney, you have to go through certain regulations to pass a bar exam, and then there's certain things you have to do each year to kind of keep yourself what's called good standing. Those aren't found in statutes, those are found in regulations. My dog here, we take our dog to, I have two dogs, but you guys are probably curious what they look like. There's one down here somewhere. That's Martha. That's my 4-year-old Golden. And the little one is down here somewhere. You see her? There she is. When we were taking our dog to a groomer, which I would have just done it myself, but I took the dog to a groomer. The dog came back with some kind of kennel cough, something like that. And my kids were saying, well, aren't there laws about, the way they keep the dogs and stuff? I said, well, I think it's like a cold, and I don't know. And I said, I'm sure they do. In order to be a licensed dog groomer, you got to go through some licensing that's created by regulations. So regulations are everywhere. I call it the Rodney Dangerfield of law, is because people don't think of them an everyday sort of occurrence like that's going to affect my life. But think about it, almost all the business practices, if a bar or a restaurant or anything like that, there's several regulations by the Alcohol and Beverage Commission that will determine whether or not you can be open certain hours and do certain things. So it's the biggest area of law. The last one, judicial decisions. It's the weakest form of law, but it really in some ways has the most significance. When courts interpret the Constitution, that's what the Constitution becomes. That's called judicial review. Famous case, Marbury versus Madison. So when the Supreme Court tells us what the Constitution means by interpreting a conflict, in a case, and says the Constitution means X, Y, and Z, that's what it will mean going forward, and we have to live with that. That's because the power of the court's called judicial review. It's not as powerful when they review a statute or a common law principle, because it can be basically nullified by the legislature. They can redraft or recreate legal standards in that realm. They just can't undo the Constitution without amending it. But judicial presidents are real important. Like today, I had a hearing, a pretty significant hearing, on whether or not the police had taken a warrant to search in a home. And there's lack of clarity. It just says in our state constitution, in our federal constitution, that we'll be free from unreasonable searches and seizures in our persons, places, and papers and facts. But what does that mean? And then it says a warrant shall issue, but only upon the showing of probable cause. Well, do you always need a warrant? Over time, the courts take judicial decisions, and they determine whether or not under some circumstances you need a warrant, in other circumstances you don't, and what is the validity of a warrant, when and under what circumstances should a warrant be given. That's almost all through judicial precedents. These precedents, these historical opinions, when they come from the appellate court or higher, give us a principle that we tend to follow in the future. And that's the Latin term from your first chapter called stare decisis. And I have somebody say, well, geez, please spell it. You're asking the wrong guy how to spell. It's S-T-A-R-E, stare, decisis, D-E-C-I-S-I-S. And stare decisis, I think in Latin, translates to let the matter stand. Once the appellate court sets a principle by interpreting a legal standard and giving it definition and meaning, we tend to follow it in future cases. And that's stare decisis, gives us predictability. And so today, when I was arguing that the search and seizure was inappropriate because it was without a warrant and it didn't meet some of the historical exceptions that the courts have given in the past. And so I brought in a bunch of cases that distinguish it, that suggest they didn't. And of course, the prosecutor brought in cases that suggested maybe the police acted appropriately under the circumstances. Judicial presidents guide the courts. And why do we like that? I mean, why do we like that as a people, as a nation? We want everybody to be treated the same. If you ever look at Lady Liberty, Lady Justice, what is she? She's a woman with a scale and a sword fighting for justice, but she's also blindfolded. We want justice to be the same for me, for you, for everybody. And let's hope we get that, or at least as close as we can to get that. And one of the ways we do it is by having consistency in the law. Statutes, constitutions, rules and regulations should be applied consistently. And how do we know when it's followed consistently? They follow the judicial precedents that courts have used in the past when they made the rulings. Did they sometimes overturn themselves and change a course of legal standards? Yeah, but it's slow in doing, and it's less likely to do it. That's called overturning a precedent. Very, very rarely done. I mean, the most famous one is Plessy versus Ferguson. Separate but equal was okay under the Constitution in 1896. Came all the way to around 1954 for Brown versus the Board of Education, before the Supreme Court says, when you separate people based upon race, it can never be equal, and it's therefore unconstitutional. But the precedent lasted for almost 60 years before the court came around and flipped it. That's what we call it, flipping it. Really colloquial term, right? Kind of very informal. But there's, like, for example, Roe v. Wade basically suggested that in the first trimester, women should have an unfettered right to control their reproductivity and therefore be eligible for an abortion if they wanted. And states couldn't curtail that. They could curtail it. They had to get it through a medical doctor and things like that, but they couldn't ban it, for lack of a better way of saying it. That's been the law since 1973 when Roe v. Wade was decided. But are there people still trying to bring it before the Supreme Court to get the court to change their mind or to narrow it, those that are on the pro-life side, as opposed to those that are on a free choice side? Those kind of arguments go back and forth, but we tend to follow judicial precedents into the future unless we get the court to change their mind, which doesn't happen, knee-jerk, not too quickly. The book, I try to keep in order with the book, and I'm going way too long already. Equity, you should know what the term equity means. Most of the time in business law, you're not going to be looking for equitable remedies. You're going to be looking for monetary, funds for being wrong. Those are called damages. Equity is the court exercising power to make what's right under the circumstances without necessarily awarding one party money or goods from the other. It's more like, hey, you have to stay off that person's property, or you have to return something. That's an equitable remedy. Courts in equity, doing what needs to be done to make justice happen. Not all courts have equitable powers. It's not that important. I don't know why it's in the book in that section. Then we have local government, which is very important. Those are like baby statutes. I call them baby statutes, ordinances, local ones. They're different in each town. Like some towns you can't, I know this sounds weird, like what am I, just a social deviant and I know these things? But like some towns it's illegal to have an open container while you're walking down the street, like an open beer can, walking down the street and drinking. Other towns it's not illegal to have an open because it's based upon local ordinance. There's no state statute on that very question. The only reason I know that, I used to be a selectman in my town, and the chief wanted to create an open container law, and I said, do we have a problem? Or a bunch of people, walking around intoxicated? He goes, no, but we don't want to have that happen. I said, well, it hasn't happened yet. Why are we creating a law when there's not a need for it? And he was concerned it was going to happen. But I live in a town where there's a lot of lakes, and there's a lot of old roads that are dirt roads and things like that. So if my neighbor's just going to walk around a lake, and he's having a beer, and he's going to walk over to his neighbor's house, and he's got to go down this public way to do it, he'd be on a public way with an open beer can. And if he's not causing trouble, he's not disturbing the peace, which is already a statute. That's a statewide statute. I didn't see the need for that local ordinances. But local ordinances can be big for business. The biggest one, zoning. And we'll get into that in chapter 3 and 4. But local ordinance is important. Make sure. So there's the four major ones: constitutions, statutes, administrative rules and regulations, and then judicial decisions. Are there others? Yeah, there's treaties between the presidents that have been approved by the Senate that have the full force and effect of law with a foreign nation. There's executive orders by a governor sometimes that have the full force and effect of law if constitutional. Same with the president, if they're allowed to do it, if they have that power in the executive under their constitutional mandates. So there's more than those, but those are the big ones. This is a survey course, basics, right? Criminal versus civil. Now it gets good, right? What's the difference between criminal versus civil? Civil are basically the society has recognized certain rights and obligations that may flow back and forth between private citizens or private companies. Those are civil claims. Those are the broadest area laws. Criminal law is much more narrow. Civil wrongs and duties, or rights and duties, don't usually inflict injury upon society as a whole. That's why when you see a case like, the Acme Company versus John Doe, it's probably civil, and it's usually a lawsuit, oftentimes over some kind of business contract. Not all civil laws over business, but much of it is contract. Might as well get into criminal. So criminal, to really define it, are acts and behaviors that are deemed detrimental to society as a whole. So if I punch my law partner in the face after having a few beers tonight, I might be charged with assault and battery. Everyone thinks, oh, your partner Mike is the victim. Well, he's the victim, but it won't be Mike Osowski versus Jim Corman. It'll be the Commonwealth versus Jim Corman, because assault and batteries are deemed detrimental to society as a whole. So criminal behavior has that, not always moral, but often a moral component to it that's deemed detrimental to society as a whole. So we want to ban that kind of conduct, and we want to give criminal sanctions, which can include fines, probation, but it also include the loss of liberty in the right circumstance. If you hear that growling in the background, my dogs are wrestling in the background. There's also a lot of differences through the different procedural rights and duties with these two kinds of claims. In criminal law, the defendant, the person charged with a crime, is always presumed innocent until and when the government can overcome that presumption of innocence by proof beyond a reasonable doubt. Very, very heavy burden. Massachusetts is defined as having an abiding conviction to a moral certitude that the defendant did the acts as alleged. It's a very tough definition to really swallow. What the hell does that mean? I like the definition that you have to have that degree of proof that leaves you without hesitation before you draw a conclusion. That's very, very difficult for the government to prove all the elements of a criminal case in order to meet that burden. In the civil case, the plaintiff brings the complaint, not the government. That plaintiff brings the complaint and has to allege that there's a cause of action, a right to sue, breach of contract, defamation of character, conversion of goods. I don't know all the different civil claims there are. There's millions of them. But it's their burden, the plaintiff's burden, when they sue the defendant, to prove, not by proof beyond a reasonable doubt, by a preponderance of the evidence. It's more probable than not the elements as alleged have been proved by the plaintiff. So it's a lower standard for the plaintiff, but the plaintiff bears the burden of proof. In the criminal case, a very high standard of proof is required, but it's the government that bears that burden. The defendant need not prove nothing. It's all on the government's shoulder to prove it. And again, what's the remedy in a civil case? If the plaintiff wins in a civil case, it's usually monetary damages, sometimes equitable, like the return of goods or stopping a behavior. You're no longer allowed to tear down that earthen berm that keeps a pond from flooding my property. I'm not asking for any money. I just don't want you to be able to tear down that wall, if you will, or that natural dam so my property doesn't get flooded. That would be my remedy, and it's civil. The other is whether or not you have a right to a jury trial. Everyone thinks you always have a right to a jury trial. This isn't communist Cuba. Well, that's not true. You're not allowed, or you're not always given the right to a jury trial in civil matters. Civil matters often will give you a right to a jury trial both by statute and sometimes in the Constitution. In the Constitution, it says that claims that were recognized at the origin of the Constitution that are worth more than $20, both the plaintiff and defendant have a right to ask for a jury trial. But not all cases back in the day when the Constitution was framed recognized jury trials. Workers' comp, not entitled to a jury trial for a workers' comp case. Divorce, family law stuff, not entitled to a jury trial for those kind of cases. Those are what we call bench trials, or trials just in front of a judge. Now in criminal law, it's the defendant and defendant alone that has the right under the Sixth Amendment to have a jury trial, determine his or her guilt, and they are presumed innocent throughout the process. So that jury, now, this new recent case on it, it also has to be unanimous in criminal. In civil, it does not have to be unanimous. It might just be a simple majority in some states. I'm not going to get the difference between all the different states. But in civil, it's usually just a simple majority of jurors have to agree that the plaintiff has either won or lost, has not bared their burden. In criminal, it's a majority, an absolute unanimous decision is required both ways. So it has to be unanimously guilty or not guilty. Don't say innocent. I've had a couple of trials before where my client's won if I'm not guilty, and some newspaper reporter comes out and goes, what happened? He goes, well, my client was found innocent today. That's a political statement because you're not found innocent. The jury might think, I think he did it. I'm just not convinced beyond a reasonable doubt, or there just wasn't enough evidence, but I think he probably did something wrong there. So it's guilty or not guilty. In either way, it has to be unanimous. What if it's not unanimous? What if the juries are out, they're deliberating, they're going and going? What are we going to do? Well, is called a mistrial because it's a hung jury. They can't come to a conclusion. Judge will give them every opportunity to go back and discuss and keep an open mind. But if they can't come to a conclusion, they can't come to a verdict, and it can go out for some time. But at some point, the judge has to say this is a mistrial because we need a unanimous decision one way or the other. It's a hung jury. The case would be dismissed, but the government usually brings back a new charge, and it just starts all over again with a new jury, a few months down the road as we prepare again for a second trial. The book does a decent job talking about the different players in a courtroom, whether something's a crime or criminal offense. The district attorney is the prosecutor usually. Defense attorney is usually someone like me. Well, maybe not like me necessarily, but I'm a defense attorney. I do mostly defense work now. The book does distinguish between felonies and misdemeanors. Your common sense should already be able to help you with that. Felonies are more serious and have more serious societal repercussions. That's why we call them felonies. And misdemeanors are just that, much more insignificant in terms of the way in which we deem they harm society as a whole. If you really want to know the definition of Massachusetts, a felony is anything that can be sentenced to a year or more in state prison, where a misdemeanor is no more than 5 years to the house of correction. It's the place and the time determines whether something's a felony and a misdemeanor. It's important that you know as a citizen, whether you're hiring people or not hiring people, if somebody says, oh, this person only has a misdemeanor conviction, it still could be a pretty nasty case, because some things that are misdemeanors surprise people and some things that are felonies often shock people. Like I always told my kids when they were younger, don't alter your license plate. That's a felony. No one goes to jail using that thing, but you could go to state prison for altering your registration of a motor vehicle document. And so you'd have a felony record, and that can be very serious for certain kinds of employment. So you should know the difference. I mean, not technically, sometimes I have to look them up, but you should at least know there's a conception that society treats things very differently, whether something's a felony or a misdemeanor. The book calls something called a wobbler. What we have there is we have concurrent jurisdiction. The case I had today was somebody that could actually do 7 years in state prison, but they reduced down the charge and left it in district court. So the maximum he would be able to get is a 2.5-year sentence to the house of correction. It's called concurrent. The book calls it a wobbler. I never heard it called that anyway. I thought this was the chapter. I think it's chapter 2 goes through with the trial process, and I'll probably put that up tomorrow. Time to get out of the monkey suit. But we're going to finish up with something that I think disturbs people when I do it live in class. But we get into this section called ethics, and ethics are extremely important. I like to think I'm extremely ethical, fair, and open, and I don't play, hide the evidence from people. And I think I have integrity, and I don't lie about things, especially in a business or a legal setting. And I think reputations are important. I'm doing it out of selfish reasons, because once people find out you're not so honest or decent or you're sneaky, it sticks with you. And I don't want that. The problem with studying ethics is that if it's not embodied in law, what are we going to do? So somebody may have done something that we say, that's really unethical. That's really, really immoral, the way in which they've conducted themselves. The question is, though, is there a law? Constitutional standard, probably not. Statutory standard, maybe. Administrative rule or regulation that applies, very possible. Or a common law principle that puts that conduct in some way to have sanction. The government can do something about it, or we can do something about it as a plaintiff. That's not always true. And so we need to study law, and law often does embody ethical principle. But many ethical and moral principles aren't embodied in law. And if there's no legal standard, I used to have a boss that used to say, well, that's up to God later on to punish that person for that, or that company for doing what they did, because there's no legal standard. We can't sue on just a sense that they did us wrong. No, we deal with it is not do business with that group again or that individual again, but the other way to deal with it is to create another law for future application. That's an important thing. It's not in the book. Criminal law and most civil laws aren't retroactive, because that would create unfairness. Otherwise it'd say, hey, this puppy's driving me crazy behind me. We would say, hey, whoever's unpopular today, next week, next month, we create a law that would somehow hurt them in some way, and we'd have it apply retroactively. We want laws to apply prospectively. It's actually in the United States Constitution. It's called ex post facto laws are not to be allowed. Otherwise, we punish all kinds of previous behaviors that were deemed innocent or legal in different settings at different times. So business ethics, very important. Legal enforceable code is more important. Most of us just have to hope for voluntary decency. And that's one of the reasons why we want contracts when we get to chapter 5. Somebody says, this guy's boring me to death. He's talking about this stuff, and he seems really into it, but I'm not. we get to chapter 5, it changes because that's how we protect ourselves from unethical, immoral, shady people, by creating contracts that protect us from potential misdeeds, if you will, to give us protection in those processes. And not always immoral. Sometimes it's just the other side had a different expectation, and all of a sudden, geez, what are we going to do? Well, we didn't hash that out. You might want to hash it out because there might be nothing you can do legally otherwise. 30 minutes for chapter 1. I was hoping to keep it down to 5 minutes. I apologize for the length. But anyways, nice to do a fresh video. I hope everyone's well. And I do mean this sincerely. Don't be afraid to shoot me a text. It's on my cell phone number, is my business number. Shoot me a text, give me a call. Especially if it's something's a little complicated. It's hard to do it over email. Give me a call or you can give me an email and say, hey, can I have office hours set up on the syllabus. Can I shoot you a buzz to go over this? But sometimes we can just communicate via email if it's something simple, especially if you take an exam and say, because you'll know your exam results on the multiple choice and true false section. Essay have to grade manually. But you might say, hey, geez, I still don't understand why I got 17 wrong. Shoot me an email, maybe we can talk about it, or I'll give you a call, or you give me a call. And sometimes this has happened before. All of a sudden, I'll go into the test, I'll take a look at question 17, and guess what? They were right. I just, when I was rushing to put up the exam on Blackboard, I had misguided the answer key, and 90% of the class got a very easy question wrong. And at least one person was courageous enough to at least inquire as to why they had a lack of understanding. Well, they understood it. It's me that screwed it up. So try to have fun with it. Ask questions. Chapter 1's a very straightforward, I think very easy question or set of content, if you will, that you're going to be able to mull right through. Otherwise, be well.